Welcome to this deep dive. Today, we are tackling one of the most fundamental, yet universally challenged rights in human history, the right to private property. It's a right that seems to transcend geography, legal traditions, and, political systems.
And yet it's constantly under threat, isn't it, from overreach of all kinds?
Exactly.
What's fascinating here, and what our sources really highlight, is that while societies across the globe have developed wildly different systems, from theocracies to democracies, they all seem to converge on this single, indispensable principle when it comes to property.
Which is?
You can't just take it away arbitrarily. There have to be rules.
Right. And that's what's so compelling about our source material for today. It's this really amazing comparative study.
It is. It draws these incredible lines.
It does. It draws links between deeply rooted moral and religious decree, specifically from the Islamic tradition, and then turns to historical constitutional law, like the U.S. Fifth Amendment's Takings Clause, and then brings it right up to the modern day with national statutes, like the ones you find in Pakistan's constitution.
And the common thread, the absolute bedrock that holds all these seemingly disparate systems together, is that principle of protection. Protection against state or even individual overreach when it comes to private assets.
Yeah, and that's a key point. This isn't just about, protecting a plot of land.
No, not at all. It's about protecting the individual's economic and personal security, their ability to plan for the future.
Okay, so let's unpack this for everyone listening. Our mission today is to extract and really analyze this universal legal and ethical bedrock, this core ratio, as the material puts it,
right,
that dictates property cannot be taken without lawful authority and compensation.
The two pillars.
The two pillars. And we're going to argue that this core standard is what separates, civil predictable governance from arbitrary tyrannical power. Understanding how it works everywhere is going to guide our whole discussion.
And if we connect this to the bigger picture, understanding this ratio is crucial, not just for individual security, that peace of mind that your home or your business investment is safe.
Sure.
It's actually crucial for the entire framework of civil society and for any kind of long-term economic stability.
How so?
Well, think about it. If you don't have predictable property rights, you completely cripple investment. Who is going to build a factory or a farm if the government can just seize it tomorrow with no recourse?
Right. You discourage capital formation. You stop long-term economic planning dead in its tracks.
Exactly. So what we're going to explore is how these different traditions, using very different language and coming from very different histories, arrive at the exact same crucial check and balance system.
A system that ensures both justice and necessity are met before any individual right is infringed upon.
Precisely.
All right, let's move right into that foundational analysis then. We have to define these two crucial non-negotiable elements. For any legitimate taking of property to happen, you need lawful authority and you need compensation.
And it's not a sliding scale, which is so important.
I mean,
you can't have a lot of authority and a little bit of compensation. It's a dual standard, a two-part test. If you fail either part, the entire action is fundamentally invalid.
So it's a pass-fail on both.
Yes. This dual standard is really a brilliant mechanism. It's designed to prevent two very specific types of abuse by the government or by other powerful entities.
Boy.
If you look at the history of property rights, they are so often the first casualty when power goes unchecked. So this ratio, it acts as a kind of civilizational safeguard against both legal nihilism and state tyranny.
Let's illustrate that.
Yeah.
I think a thought experiment might help here to show why you need both.
Good idea.
Okay, so let's imagine a scenario where you have compensation, but you don't have lawful authority.
Okay.
Let's say a powerful but totally unauthorized entity,
Yeah.
maybe a big corporation or even
Yeah.
just an influential local gang, decides they really need your factory site for their own private plans.
And they come to you with a great offer.
A fantastic offer. They give you fair market value, maybe even a generous premium on top,
Like-
but then they just forcibly take it,
Well, that's just institutionalized theft.
even with the money.
Absolutely. It doesn't matter how much money changes hands. The compensation might make it polite theft, but it's still theft. Why? Because the entity taking the property has no rightful, legal, or constitutional mandate to do it.
So the origin of the act matters.
It's everything. The act has to come from a legitimate, recognized governmental power that is operating strictly within its defined legal parameters. If the taking authority isn't legislated, if it's not transparent and defined by law, the payment is totally irrelevant from a legal standpoint.
Okay, so now let's flip it. Let's look at the other side of that coin, which is probably the more common and insidious abuse.
Right.
You have lawful authority, but there's no compensation.
This is the classic form of state confiscation, or eminent domain abuse, as it's often called.
So the government comes in and claims some urgent public necessity. Maybe they need to build a massive highway or a new military base.
And they have the clear enshrined legal right of eminent domain to do it. The authority is not in question.
Correct. But they offer the owner nothing. Or maybe, a fraction of the true value, some token amount.
Well, in that instance, the state is effectively forcing a single private citizen or a small group of citizens to subsidize an enormous public benefit entirely out of their own private pocket.
Which is fundamentally unjust.
It's profoundly unjust. It violates the basic principle of equality under the law. The logic is simple. If the public benefits from the property, then the public purse has to pay for it. The existence of legal authority doesn't negate the individual's economic loss. It just legitimizes the necessity of the action.
So there's the analytical nexus, right? This dual standard defines that strict, razor-thin boundary between a justifiable state necessity, what we call eminent domain or compulsory acquisition, and the sanctity of an individual's economic stability.
And policing that tightrope walk of government power is the core challenge for any legal system.
It is. And that brings us to the concept of lawful authority, because it's much more complex than just saying, oh, the government passed a rule.
It's so much more. It demands strict adherence to what lawyers call due process.
Okay, break that down for us. What does due process mean here?
Firstly, the state's action has to be transparent. Everyone needs to know what's happening and why. No backroom deals.
Okay.
Secondly, it has to be regulated. It's typically mandated and defined by a specific act of Parliament or Congress. It can't be whimsical.
And thirdly?
And crucially, it must be justified by a demonstrable, genuine public need. Not just the arbitrary desire or, the political expediency of a single official or a political party.
Arbitrariness. In its context, that's the real enemy of lawful authority, isn't it?
It is the enemy. If the underlying authority isn't lawful, the taking is illegal, period. If the process is opaque, if it's non-judicial or politically motivated, then the authority is deeply suspect.
So the law has to provide really clear rules about who can initiate the taking, how they have to announce it, and what justification they must offer.
Yes, and it must allow for a judicial challenge at every single stage of the process.
Right.
And to zoom out just a bit on this concept, this two-part ratio is what transforms property protection from a simple political promise. A gesture that can be granted or revoked by whoever is in power.
Into an enforceable legal right.
An enforceable legal right that can be rigorously tested and defended in the highest court of the land. It's what gives the citizen indispensable legal recourse against the entire state apparatus.
Okay, so that's lawful authority. Let's dive deeper now into the second half of that ratio, compensation.
Right.
When we look across these different legal traditions globally, what exactly does compensation mean? Is it just a handshake and some nominal amount?
Absolutely not. In every major legal framework we're looking at, the compensation must be defined as just.
Just compensation.
Yes. And the universal legal standard for that ensures that the owner is held harmless by the transaction. The goal is restoration, not penalization. They should be reimbursed precisely at the property's fair market value, or FMV.
And that's calculated objectively at the time of the taking.
Yes, at the moment of the taking.
So let's say I've been operating a small business on this piece of land for 20 years. The compensation has to cover what the land is worth on the open market today.
Correct.
Regardless of how much my family values the location, or how cheaply the government hopes to use the land for its project.
That's exactly right, and that highlights a frequent point of contention in these cases. The focus is strictly on the objective market value that the owner lost.
Not sentimental value.
Not sentimental value, nor the potential profit the government might make from its new development, nor any speculative value the owner hoped to realize in the future. The law demands objectivity.
And payment has to be prompt, I assume?
It does. Furthermore, the compensation often needs to be prompt and effective. A promise to pay you in 10 years, or a payment that's tied up in endless bureaucratic red tape that is not considered just compensation. It violates the spirit of holding the owner harmless in the immediate term.
This raises a really important question about the whole check and balance system then. How does the legal system make sure that the determination of lawful authority is genuinely objective? that it's not just a rubber stamp for whatever the executive branch wants to do, because if the courts simply approve any infrastructure project the government proposes, then the safeguard is pretty meaningless.
That is where the function of robust judicial review becomes absolutely non-negotiable.
So it's up to the courts to be the final check.
It is. The determination of lawful authority has to be subjected to very stringent tests of necessity and proportionality. The courts have to ensure that the asserted public need is genuine and not just a pretext for something else.
Like what?
Well, they have to actively look for situations where the government might be abusing its power. For instance, by transferring property from one private owner to another purely for increased tax revenue, rather than for genuine public access or use.
Which we'll get into later.
Exactly. This kind of rigorous judicial oversight is the final essential line of defense that separates constitutional governance from authoritarian rule.
Okay, so these strict legal structures we're about to look at, they basically provide the scaffolding for that oversight. They move us from this abstract theory of the dual ratio into specific applied legal traditions.
That's a good way to put it.
So let's transition now. We're moving from the abstract legal test to the deepest ethical and historical root that's mentioned in our source material. We're going to look at the moral and religious foundation that underpins legal systems in the Islamic tradition. The prophets, peace be upon him, explicit condemnation of the unlawful seizure of land.
This is a critical pivot in our discussion because it elevates the sanctity of property not just to a matter of civil contract or, constitutional protection, but to a deep, non-negotiable moral and religious obligation. It establishes property rights as inherently sacred.
And in the legal systems that are derived from this tradition, the right to property, it's known as ḥurmah, is considered one of the 5 necessities, the daruriyat, that the Sharia aims to protect.
Right alongside religion, life, intellect, and progeny.
That immediate inclusion, putting it on the same level as life itself, it just shows the elevated and fundamental status of property protection right at the ethical core of the system.
And the condemnation for violating it is extraordinarily severe. It acts as a profound spiritual deterrent.
How so?
Well, it's reported in several authentic traditions, or ahadith, that whoever unlawfully takes even a span of land will face an immense spiritual penalty.
What kind of penalty?
Literally having 7 earths piled around his neck on the Day of Judgment. I mean, this goes so far beyond a mere legal penalty. It establishes a massive spiritual barrier against arbitrary seizure.
Wow. I mean, that degree of severity places an immediate high moral barrier in front of any government or individual who's even contemplating expropriation.
It does.
It instantly suggests that unlawful acquisition isn't just, a regulatory infraction. It's seen as an act of profound injustice, a violation against both God and man.
And we need to focus on the definition of unlawful seizure in this context. It's broadly encompassed by the concept of gasp.
Gasp.
It's defined as seizing property without a rightful claim or permission, irrespective of whether the means used were force or coercion or even deceit.
And this applied to everyone.
Critically, this definition applies equally to the most powerful ruler and the poorest citizen. There are no exceptions.
So let me connect this back. If a state, claiming some vague necessity, takes land, but fails that lawful authority and compensation ratio we established in Section 1, does that action morally fall under the spiritual condemnation of gas?
Absolutely. The inherent sanctity of ḥurmah means that any government or individual action that is non-consensual and non-compensated, or that lacks a genuine, morally justified public necessity, what's called maslahah, it falls under the severe moral condemnation.
So to establish the righteousness of the possession, you need one of 2 things.
Right. You either need the property owner's full consent, or you need a clear, legally defined, and fully compensated transaction. Anything less is fundamentally unjust.
What's so insightful about this moral underpinning is that it doesn't wait for a codified constitution or a secular court ruling to take effect, does it?
Not at all. It predates secular law entirely. And it provides the ethical imperative that subsequent legal systems have tried to codify.
It's the source code, in a way?
It is. It provides the essential ethical foundation for the lawful authority element of our core ratio. It insists that the method of acquisition must be morally and religiously justified, not merely powerful or expedient.
So for a taking to be lawful in this context, it has to adhere strictly to principles of justice, or adl, and proven public interest, maslahah.
Yes. This mandates fairness, transparency, and most importantly, justice in all dealings involving land and property.
This grounding ensures that state power is always viewed with a healthy dose of skepticism when it infringes on private assets.
It has to be. If a ruler decides to seize land for purely personal enrichment or to reward a crony, or without any genuine public benefit?
They're violating a fundamental religious tenet, not just a civil law.
Precisely. The condemnation holds moral weight, even if the state's technical written law might be weak or silent on the issue.
So this emphasis on ethical justification means that even if a state claims to have legal authority, say, through some rubber-stamped ordinance, if that authority is demonstrably unjust, arbitrary, or serves no righteous public purpose, it is still morally condemned as gassed.
Which sets a notably high standard for the legitimacy required for the state's exercise of power over property.
Okay, so to summarize the Islamic foundation here, it basically reinforces the universal secular principle by putting profound spiritual weight behind the requirement for justice. It ensures that the action must not just be lawful in a technical sense, but it also has to be morally righteous and justified. It makes the defense of property incredibly robust from the very foundation.
Precisely. And it connects the dots for us. Property is viewed not as a state-granted privilege, which can be withdrawn at will,
Right.
but as a fundamental human right that the state has a moral duty to protect. The state can only encroach upon it in cases of proven extreme necessity, and even then, always with full, immediate compensation.
Okay, so from that deep ethical root, let's now move to what is perhaps the most influential secular articulation of this protection in constitutional law. The Takings Clause of the U.S. Fifth Amendment, ratified in 1791. The language is, it's the direct ancestor of countless modern constitutional provisions.
It is.
Nor shall private property be taken for public use without just compensation.
Simple, powerful, and the cornerstone of property rights in the United States. And it has influenced constitutional drafting across the globe, including in the very Constitution we're going to examine next.
It is the direct legal embodiment of our core ratio, isn't it?
It is. Lawful authority, framed as public use, and compensation, explicitly defined as just compensation. It's all right there.
Okay, so let's unpack the most contentious element of that clause first. Public use.
Right.
Originally, when the U.S. was founded, the courts interpreted this term quite narrowly.
Very narrowly. It meant things the public would literally use. Public infrastructure like military forts, public roads, post offices.
Things directly and physically used by the general public.
Oh, yeah.
It provided a very strong, measurable boundary on state power.
That narrow, literal interpretation was designed to be a strong check against governmental overreach. But over the 20th, and especially the 21st centuries, the definition of public use has expanded considerably.
And often controversially.
Very controversially. It's blurred the lines between true public necessity and, well, private economic development that's just engineered by the state.
We have to address the most significant flashpoint in this evolution, which is the 2005 Supreme Court case, Kalo v. City of New London.
A landmark case, for all the wrong reasons, in many people's eyes.
In a highly criticized 5-4 decision, the court ruled that the City of New London could use eminent domain to seize private homes.
Perfectly fine, well-kept homes.
And then subsequently transfer that land to a private developer for a massive commercial economic development project.
That ruling effectively redefined public use to include the much broader concept of public purpose.
And what was the argument there, the justification?
The argument was that the economic benefits of the new project, so increased tax revenue, job creation, urban revitalization, could justify the taking, even though the land ended up in the hands of another private entity, not for public access.
It was a massive shift in how lawful authority was interpreted.
A sea change. And the political and legal backlash was immediate and fierce.
Right. Well, the Supreme Court decision set the federal standard. We saw this huge surge in state-level legislative action.
We did. Within just a few years, 45 out of the 50 U.S. states passed new laws that explicitly restricted the use of eminent domain.
Specifically to counter Kalo.
Exactly. Often prohibiting the transfer of condemned land to private parties for purely economic development. They were directly pushing back against the Supreme Court's broad interpretation.
That state-level response is extremely important for our deep dive, isn't it? Because it demonstrates this inherent ongoing tension within the core ratio.
It really does. It shows that even when lawful authority is technically met through a Supreme Court ruling, if the public perceives the action as lacking a moral or genuine necessity, the political and legal systems will respond to reinforce that original, stricter idea of property sanctity.
Okay, so that's duress physical condemnation. Let's pivot now and examine the second crucial aspect of U.S. takings law, which is far more subtle and, I think, more complex.
Right. Regulatory taking.
Regulatory takings.
This is a really sophisticated check on state power. A regulatory taking happens when the government doesn't physically take your land.
They don't send in bulldozers.
No. But they implement regulations like overly strict zoning laws or severe environmental protections or density restrictions that are so restrictive they strip the property of virtually all its economic value.
So you're left holding a deed to a property that you can't use or sell.
Precisely.
So if the government enacts a regulation designating my 5-acre commercial parcel as a protected wetland where no construction or development is permitted, I haven't physically lost the deed, but I have functionally lost the economic asset I purchased.
You have. And the courts have developed specific, detailed tests to analyze this, rather than relying on some simple blanket rule. The most influential is the Penn Central Test, established in 1978.
The Penn Central Test.
Right. This test requires courts to balance 3 factors to determine if a regulation has gone too far and therefore requires compensation.
Okay, what's factor 1?
Factor 1 is the economic impact of the regulation on the claimant. How severe is the financial loss? Did the value of your property drop by 10% or by 90%? The more severe, the more it looks like a taking.
Okay, makes sense. Factor 2.
Factor 2 is the extent to which the regulation interferes with distinct investment-backed expectations.
What does that mean in plain English?
It means, did you buy the land specifically to build a house and the government knew that? Or did the regulation predate your purchase, meaning you should have known the risk? It looks at the owner's reasonable reliance on the law as it existed when they invested.
I see. And factor 3.
And factor 3 is the character of the governmental action. Is the government acting to prevent a public harm like stopping you from polluting a river? Or is it acquiring a public benefit like creating a public nature preserve on your land? The first one is less likely to be a taking, but the second one, acquiring a benefit, feels a lot more like something the public should have to purchase through eminent domain.
And the ability to argue and quantify these 3 factors in court, that's a critical legal achievement.
It is. It prevents the state from achieving uncompensated expropriation through, bureaucratic or environmental rules, rather than direct physical force. If a regulation denies the property owner of all economically beneficial use, compensation is required.
Okay, and just to close the loop on this section, let's quickly revisit the just compensation mechanics.
Sure.
The courts focus solely on fair market value, or FMV.
Yes, and that valuation typically excludes things like business losses the owner suffers from having to relocate. It excludes any sentimental value attached to the property and even attorney fees, although some state laws do offer exceptions.
So the standard remains rigorously objective.
It does. The question is, what would a willing buyer pay a willing seller on the date of the taking? That analysis reinforces the idea that the individual must be made whole financially, but they can't expect the public to compensate for subjective, non-economic losses.
So the U.S. system, through the courts, provides this clear judicial oversight over the state's definition of lawful authority, making it a really sophisticated mechanism for protecting property.
It is, though, as we saw with Kilo, it's constantly being tested and debated.
Let's shift our focus now. Let's see how this universal principle is codified in a modern national framework. We're referencing Pakistan's constitution, Articles 23 and 24, as detailed in our source material. This provides a crucial point of comparison, I think. It shows how a modern constitutional state can integrate both those ancient ethical norms we discussed and these more modern secular legal structures.
It's an excellent comparison because Pakistan's constitution, like many post-colonial constitutions, does something very specific. It explicitly states the fundamental rights up front, and then it carefully defines the narrow limitations on those rights in the subsequent articles.
So it's hardwiring the necessary compensation and authority ratio directly into its supreme law.
That's exactly what it's doing.
Okay, so let's start with Article 23. This is the positive declaration of the right itself.
Right.
It establishes the fundamental right of every citizen to acquire, hold, and dispose of property subject only to law.
That is a powerful declarative statement. It says that ownership is a given right. It's derived from citizenship and morality, not from some temporary state favor that can be given and taken away.
That positive declaration is absolutely vital, isn't it? Because it sets the starting position. The default is the citizen's absolute right to their property.
Yes. And therefore, any state action that infringes upon that right must be treated as a necessary exception that requires rigorous legal and moral justification. The burden of proof is on the state.
And then we move to Article 24. This is the operative takings clause in the Pakistani constitution.
Yeah.
It deals specifically with compulsory acquisition, the formal mechanism of taking property against the owner's will.
And Article 24 stipulates two crucial and specific criteria that must be met for that compulsory acquisition to be valid. And these 2 points are the direct national application of that universal ratio we've been discussing this whole time.
Okay, criterion 1.
The acquisition must be for a public purpose.
Criteria 2.
It must provide for the payment of compensation that is determined and paid strictly in accordance with the law.
Let's draw a detailed comparison here on the terminology. The U.S. Fifth Amendment uses public use, which, as we saw, was judicially stretched to mean public purpose. Pakistan's Article 24, however, uses the term public purpose directly from the start. How does that difference affect interpretation and judicial review in the Pakistani context?
That's a great question. While public purpose is inherently broader than the original narrow meaning of public use in the Pakistani context, the interpretation is highly guided by judicial oversight aimed at preventing arbitrariness.
So the courts play a similar role.
They do. They must ensure the purpose genuinely serves the interests of the community at large, things like infrastructure, defense, public health. But importantly, the constitutional framers would have been deeply aware of the moral imperatives we discussed earlier, like maslahah and adl from the Islamic foundation.
So that ethical framework informs the legal one.
Exactly. They would have structured the requirement for public purpose to necessitate a high bar of justification, specifically to prevent the kind of private-to-private transfer abuse we saw in some of the American interpretations. So this emphasis on purpose ensures that the moral and ethical justification, the concept of utility and justice, remains deeply embedded even in the secular constitutional framework.
It does. The taking must be justifiable on strong utilitarian and ethical grounds for the society, making it a powerful check against state misuse.
And this leads us to that critical procedural detail. Article 24 explicitly ties the determination and payment of compensation to the law.
Yes, it says compensation must be determined and paid in accordance with the law. This is a crucial procedural safeguard. It guarantees the predictability and certainty we talked about at the beginning.
Can you elaborate on what in accordance with the law means in practice? What does that look like for a citizen?
It means that a specific statute, historically, often a law like the Land Acquisition Act, which is separate from the Constitution, must prescribe the mechanisms for valuing the land.
So it's all laid out.
It's all laid out. That law details the method for appealing the valuation, the timing of the payment, and the process for challenging any deficiencies. A citizen doesn't have to rely on some arbitrary administrative ruling. The process is laid out clearly in statute.
Which directly satisfies the compensation part of the universal ratio and provides clarity and recourse.
It's an effective system of checks and balances. The principle is enshrined in the Constitution, and the execution is strictly regulated by procedural law.
So to synthesize, the robust inclusion of Articles 23 and 24 ensures the constitutional defense of property rights against arbitrary actions by the executive branch.
It really does. It demonstrates how that universal core principle lawful authority paired with financial indemnification has been seamlessly integrated into the constitutional structure of a modern state.
And it provides a clear, enforceable legal basis for citizens to challenge improper takings in the highest courts. You know, it's just powerful how these different legal traditions, one based in deep religious ethics, another in 18th century revolutionary thought, and the third in modern nation building, they all arrive at the exact same two-part legal architecture to protect property.
It speaks volumes about the universality of this concept of fairness, doesn't it?
It really does.
It speaks directly to the fundamental understanding that a person's individual security and liberty are directly tied to the security and predictability of their assets. Any political or legal system that fails to protect property reliably fails fundamentally to protect liberty reliably.
So we've completed our deep dive. We've analyzed traditions spanning centuries and continents. We started with a moral imperative against unlawful seizure, that concept of GASP. We moved through the sophisticated constitutional checks of the Fifth Amendment, including the complexities of physical versus regulatory takings.
Right.
And we landed on the codified protection within Pakistan's foundational law, Articles 23 and 24. And despite these varied origins, the conclusion remains completely unified.
So what does this all mean for you, the listener? It means the protection of property relies universally on this tandem requirement: legitimate justification and financial indemnification.
From the moral decree of the prophet, peace be upon him, condemning gasp and insisting on righteous acquisition,
To the secular demands of public use and just compensation in the U.S.
and the public purpose and prescribed compensation in Articles 23 and 24, the boundary on state power is crystal clear.
If the state acts arbitrarily, if it fails to follow due process, or if it attempts to seize property for private gain, it lacks lawful authority.
And if the state takes without paying prompt, fair market value, it fails the compensation test.
You absolutely need both of those pillars to stand for the action to be legitimate in a civil society.
And if we connect this to the bigger picture one last time, the universality of this rule is just a powerful testament to the essential role of predictable property rights.
They guarantee individual liberty and they foster a functional, stable society. Predictable rights are not merely some legal nicety. They are a prerequisite for all long-term capital investment, for economic stability, and for civil order.
They signal to both domestic citizens and international investors that the state respects the individual and is itself bound by the law.
And this whole discussion reinforces the concept that rights are not absolute, but they're defined in relation to public necessity. Your right to hold property is subordinate only to a demonstrable public necessity.
And even then, that necessity must be paid for by the society that ultimately benefits from the property acquisition.
Which raises a really important question, particularly given our modern economic realities. Our sources focused heavily, as most historical legal systems do, on land and physical property.
Yeah. Tangible assets.
Exactly. But as modern economies increasingly rely on intellectual property, on data, proprietary algorithms, and digital assets, assets that aren't physical plots of land, how will the definition of compensation and taking evolve to protect these new forms of property under these existing constitutional frameworks?
That is the central challenge that's already before the courts globally, isn't it?
It is.
I mean, is the government requiring access to my encrypted personal or corporate data a form of taking if it compromises trade secrets or economic value?
Or is the arbitrary revocation of a government license, a digital patent, or a valuable spectrum allocation license a regulatory taking that strips that asset of all its functional value?
The foundational two-part principle, justification and compensation, it still remains valid.
It has to. But the application is moving into complex, undefined territory. Determining the fair market value of a proprietary algorithm or a massive data set is infinitely harder than valuing an acre of farmland.
So the courts now have to interpret just compensation and public purpose in this fluid, rapidly evolving digital age.
The mechanism has to stretch to cover non-corporeal wealth.
And that leaves us with our final thought for you to consider as you wrap up this deep dive. Given the profound moral weight assigned in the Islamic tradition to the unlawful seizure of land, to gav, how should modern society morally and legally categorize the large-scale unlawful seizure of a digital identity, of personal data, or of fundamental digital assets? What would the ethical equivalent of that condemnation look like, and what just compensation, physical or otherwise, is owed in those cases?
A lot to think about there.
Something for you to chew on until our next deep dive.